Thank you very much for the invitation to the Institute and also to Dr. Stocker and also many other researchers here, which I had the pleasure of meeting before, and we are very happy to, since many years. And I shall say this is a special occasion to be in Germany, which much of my philosophical thought is inspired by German thinkers. And I took the pain to go to Germany when I was in high school, when I was about 17 years old, where everybody else went to Australia and California for surfing and stuff. And I went to Erfurt, which is a small German town, and everyone was quite surprised over that. It was a very good experience because I learned German and I was accustomed to much of the German philosophy. And this I could use many, many years later when I was doing my PhD on the subject of unfair pricing, because as you know, there is a law against unfair pricing in EU competition law in Article 102. And then there's an associated case, which is called United Brands, which then gives us a schema. And then there's a writing in United Brands that caught my attention, which is about fairness or unfair when compared or unfair in itself. When I read that, I knew immediately the one or the ones who wrote that were students of Immanuel Kant. Otherwise, you would not make such a writing. And then this necessitated to create a more Kantian approach to how we can approach law and economics of fairness. Transitioning further to the matter of digital and I was moved by the amount of fairness that just rammed through all the holes, despite the fairness being cast as rather controversial and complex. So just to solidify, as a student of fairness, of course, I am moved by the amount of fairness buzz being created. Again, I'm also worried because I know how complex it was to just define what is an unfair price under Article 102. It has created immense debates in competition law and economics, and it's only one sentence, okay? Now you open up DMA, it's fairness everywhere. And when we have this huge disagreement in competition law about one sentence, imagine how much disagreement we will face in the law and economic society when there's 43 references to fairness and there is no case even to define it. At least in 102, we have lots of cases. United Brands, of course, but then we have 100 other cases. Now we have how many cases on DMA? Very few. So this causes a war. Next slide, please. Now, we can very quickly talk about that. There are different approaches to fairness. If you read Kant, there's one approach to fairness as in equal respect and universal practical reason. Persons may not be treated merely as means and should be approached as autonomous. We have Rawls, which more talks about fair terms of social cooperation, liberties, opportunities, and he engages in a trade-off that Kant does not. And also going into the moral arbitrariness of starting positions and so, you know, this veil of ignorance schema that he has and so on. And then we can go even further back to the works of Aristotle, which both Kant and Rawls relied upon, and which in his term, it is a more Rawlsian version that justice is as fairness, right? So it's more the corrective and commutative justice. And the fairness in transactions concerns equality between performances and correction of wrong from gain. So Aristotle is the one who has given us the basis of unequal transaction being unfair in and out of themselves. Now, there's a long time since then, we have now moved on to behavioral economics, and we can test empirically and neurologically, we can test various fairness approaches. There is an institute called FAIR, which is associated to Norwegian Business School, when I did my researches there last year around the same time. And it is the most cutting edge when it's about fairness research, and they do universal empirical research on that subject. And what they find is that we find rather coherent universal approaches to fairness. It is not so that people in Korea have a widely different idea of what is fair than people in Switzerland. It is quite same. We feel that those who work hard should be rewarded more. We feel that tax system should be, treating everybody equal. We feel that the playing field should be level, right? So these are some things that we can extract from there. So is fairness subjective? Yes. But is it entirely unworkable? Can't we find any sustained approaches? Yes, we can. And we see this. Some of the work that they have done builds upon the work of Kahneman and Stiglitz and Fair, who were awarded also with the Nobel Prize. Now, having said that, look then at DMA. We find 43 references to fairness in DMA. It talks about what is unfair practices. Well, when there is an unequal transaction. Again, you would argue that in any business, when you're doing a good business, there's an unequal transaction, right? But how unequal? What is the dominance factors? What are the willingness, autonomy of the parties, and so on and so forth? Sometimes you enter into a business, you sell low because you have a higher expectation of getting a long-term contract, and so on and so forth. So there are myriads of contexts dictating what is fair in a certain context. What DMA does not is that give us a working definition of fairness. It is rather wish-washy, and it's a rather Aristotelian, and then it refers back to competition law norms on fairness, as if there would be a very clear consensus on the competition law norms of fairness. And I know there are not. I just wrote a whole PhD necessitating that there was no such consensus. If there was, there would be no need for such a PhD, and the likes. We go into DSA now. Now, DSA is more pertaining to consumer protection. You could also argue that DMA also has that, but at a more macro level, right? And here we get into a grand debate, which I will avoid today, which is about the approaches in competition law to market regulation and the approaches in consumer law to market regulation or consumer protection. If they pursue the same aim, if they do it in the same way, if it's the matter of the same form or same kind, and so on and so forth. There's a lot to be said about that, but not for now. The AI Act is more ex ante. It really categorizes some situations, some techniques, some certain instances where it is necessitated a more holistic approach to what can be fair, but then they infer their fairness norms not within the act. They infer it from some other acts, other perspectives, other policy formulations by the European Parliament, for example, that what do we call unbiased or non-discriminatory and so on. Moving on to the Data Act, here we get more classic. Here it is much more competition law approach. It's about fair access, it's about essential facilities, basically, that data creates and so on and so forth. Much more within, the known territory, right? And then we have the P2B regulation, and then fairness and transparency in the platform to business contracts and so on. That gets a bit further back to the consumer law protection again, right? So there's a mixture of these approaches in these acts. Now, another problem is that me and Fabrizio have been discussing a lot because I was also working at the Swedish Competition Authority as a senior lawyer, so I saw the institutional realities firsthand, right? So I am quite aware of the practical issues. we have an institutional confusion here, right? So which institutes should be tasked by this? And are they really correct institutes, even if they have been designated as such? Sometimes you hear about this matter of double jeopardy, right? Making a buzz now. That, oh, you can be castigated under both DMA, but also the data, the classic meta Bundeskartellamt. I would argue that although the risk might exist in a theoretical setting, the practical application of it is akin to zero. Why? Because most of these teams, they share the same office. They talk, right? So basically, Swedish Competition Authority is also the one who has been tasked with having the DMA. Now, the DMA unit people have lunch together with other units. So obviously, there's a lot of sharing of experience formally and informally, right? So obviously, when we have formal meetings on which case we prioritize, if I hear that, oh, you are prioritizing meta as well, of course we're not going to go on. Of course we have to. So the institutional aspects sometimes are lacking in some part of the scholarly debate, so we say. Fairness is one thing, doctrinal, philosophical, subjective, and so on. But consumer welfare standard, that should be rather uncontroversial on things, right? Because if you read the EU competition law policy, which aim does EU competition law policy pursues? Well, multitude of market integration, for example, right? But you really find in a lot of documents and policy that EU competition law should pursue consumer welfare standard. And then it's that this is the accepted agreement, this is the consensus. If you go to the Bundeskartellamt, ask them, what do you do? Well, we pursue consumer welfare. You go to the Swedish Competition Authority, they will ask you the same thing. It's actually in their tagline. We pursue consumer welfare. So one would expect that there is a working definition of consumer welfare and standard. I might disappoint you. There is no such thing. Because, and this is not me saying this is one of the grand old lady of competition law saying this, Eleanor Fox. And the problem is that, firstly, we have an Atlantic divide. In the US, they call it the consumer welfare standard, but they don't mean that. They mean the total welfare standard in the Borkian notion. In EU, we really mean the consumer welfare standard, but even on that, we don't really agree what content it should have in all aspects. So I think both me and Fabrizio have written a lot about the Borkian confusion and the Posnerian confusion when they try to integrate, some European law standards. And there's a wonderful book by Hans-Joachim Mestmacher, which is called A Legal Theory Without Law, which is wonderful. And he exposes that in the Posner reading of Kant, Kant is no longer a Kantian, which is an amazing achievement, I must say. And this is one of the problems, and this is the problem we face. There's another article, more recent, by George A. Verden in European Competition Law Journal, which talks about the exploitative nature of Article 102. And it's an exemplary article in how you can get everything wrong about a jurisdiction about which you don't really know so much, right? So this Borkian approach that we sometimes see, we can see that contours of it in the more economic approach that now is pretty dead and gone, but it made the ways for a long time. You could see a lot of these things. You can see some references even in some court cases to this kind of. So this is rather concerning, because if we are to move into a more fairness-oriented market regulation, then we have no use of these theories, because they are obviously against having a fairness as a concept in the market regulation. Everything should be about economic efficiency. So it is not only semantics, but this is substance. On the substance, we have a lot of problem with this. and the matter of what can be said to be categorized as a market price, right? And what is the fair market price, for example. There's a huge difference in the EU law approach to that or in the more Chicagoan version to that, which take the price as given, right? We don't. Okay. And next slide, please. So basically, and now we are on the why this matters for EU law slide, I hope. Yeah, good. So I believe very strongly that various areas of law can pursue mutual common aims. I do not believe, however, that all nuances disappear. I do believe that fairness in competition law might mean one thing, while in a contract or consumer law can mean something else. This does not mean that competition law or consumer law do not pursue fairness in the same way, but it's a difference not only in form, but in kind. So I think competition law should more pertain to macro market regulation, being more consequence neutral. Whilst consumer law can never be consequence neutral. The protection of the consumer is the be-all, end-all of that law. But I'm not quite sure this tension should really affect the enforcement, because everything about this is about actually enforcement, right? Which Fabrizio, I think, will talk a little more about. So we can try to marry these bodies of law, but then we need a bridge. If we use, in our proposition, by me and Fabrizio, consumer sovereignty, then we can speak to the competition law crowd, to the consumer law crowd, and to the digital regulation crowd. This marries the macro market regulation with the micro consumer law protection, but also what you call it, the digital data regulation, which is pertaining to both parties, basically, right? And then consumer harm can then be mediated through the competitive structure, or rather the protection of the competitive structure. And not only end user losses, because this has been a problem for competition law, that where we have seen manifest market problems, but then certain bodies of economics have then criticized the approach, the per se approach, by object approach, and said that, okay, this is against the law, obviously, but is it really bad? Have you shown the negative effects? As if in a murder case you would argue that yes, but it's also bad. I mean, we have per se rules because we have seen that such behavior leads to negative approach, or else we would not have those per se rules. But then our friends on the other side argue that, yeah, but that was a long time ago. You should update your analysis. You should change the law. They know the law will not be changed, because then we need to gather all of the European countries and agree on a treaty change. Not going to happen. So what they're trying to do, they're trying to change the application of the law. And that's a big debate to do that. So competition on the merit, it can be a fairness benchmark. And if going over to the consumer law, the average consumer benchmark can also be, updated against. It is also work done by another parts of our network, Emilia Mesenjic and her colleagues, Fabrizio also. And a little bit about, the information duties. They cannot in and out of themselves avail the companies in their compliance. We need something more. We need some proper actual access or proper actual engagement with the end user request and so on. And finally, the fairness clauses, they really need a substantive benchmark. This is what our research project is about. So hopefully in 3 years or 2.5 years, something, we will be able to come with a very narrow, practical, objective assessment model to Swedish Competition Authority. My aim is basically that you get a complaint, then you will just run it through this model and it will go yes, no, yes, no, yes, no. And at the end, you know if it has broken the law or not, and you have all the benchmarks and so on and so forth. We desperately need some DMA case law. So hopefully in the coming years it will emerge. I put my hope into that so that the court will do a little bit of our work for us. If not, we're going to do the work of the court for the court, hopefully. So we'll see who gets past the first post first. So thank you very much. I pass over to Fabrizio.
So thank you, Behrang, but also thank you for the invite. And Volker, in particular, thank you for pronouncing my name so well. It is so hard to hear my name perfectly pronounced, both the name and the surname. Thank you. Now, the main important, the most important thing I think that I have come across in my research is a quote which is some that goes more or less along these lines. Consumption is the sole end of production, and the interest of the producer should be followed only as far as it is instrumental to the interest of the consumer. The maxim is so perfectly self-evident that it would be that attempting to prove it would be absurd. And when I read that, I thought, in a law and economics framework that is where it is so difficult to make distributive concerns between market participants matter, this idea sounds quite heterodox. Does any of the participants know where does this come from? No, that's Adam Smith in The Wealth of the Nations. Okay, so the guy that is mocked as the starter of the size of the pie idea, distributional insensitivity, and so on, instead was then given by a later scholar in the early 20th century, William Hutt, who conceptualized consumer sovereignty explicitly as the main originator of this idea. And for us, this is a very useful standpoint because it is institutionally neutral. So this raises a claim about people interact on the market with each other, and it introduces an idea of role inequality. We're not so much interested in the equality between, in terms of outcomes for the consumer and the producer. There are certain problematic readings of Aristotle where equality in exchange is equality in the distribution of the surplus. Not really. And then one of the things that we are interested in this network is the fact that there are these older concepts that you can see as being poorly managed in contemporary discourse that carry a lot of justificatory capacity, and we are operating in very complex sectors where business practices can be can have enormous levels of complexity. And if the practice is complex and our frameworks are uncertain, then what we get is systematic incapacity to intervene further. And there is a concept that is used in competition law parlance sometimes, which is confusopoly, and this is used to talk about certain market strategies that allow firms to essentially benefit from too much information. But I think, and for me it is really important to stress how we are as academics, right, the intelligentsia in theory, we are contributing with our lack of effort to simplify the conceptual frameworks, the analytical frameworks, the tests to be applied. We are contributing to the increase of the enforcement cost, of the compliance cost, of the supervision costs. And when this happens, there is always one side that wins, and that is not the consumer. So it is really important to try to simplify the stage where people need to understand exactly what they want to achieve. And we think that consumer sovereignty is a very useful concept to talk about these matters. It works well in the analogical economy, and it works well also in the digital economy. And one of the reasons why it is worth pursuing is that it allows to do something that is quite, I think, significant from a theoretical point of view. So one of the things that Behrang stressed is, for example, that you cannot reduce fairness language to utility language. But this is a problem of translation, so to speak. And that's fine, because there is another type of relationship that you can identify between different concepts, and that is one of vertical or structural integration, where essentially you ask yourself if claims that are moved at one level of generality can be translated into justifications for claims at a different level of generality. And being methodological individualist deep down, if you really, if taken at gunpoint, the account that I am more interested in, and the one where consumer sovereignty does a lot of interesting work, is an idea of moving from the individual level to the contractual level to the market level. So autonomy, equality, and then efficiency. And when you do that, you can start to see some order, because, for example, people have criticized total welfare as a normative concept because it doesn't work well with the idea of substantive equality that liberals endorse. But that's fine. But the problem is that it works well with the idea of formal equality. Why? Because the state is capable of telling you that the exercise of monopoly power is bad, even without choosing to pick sides between consumers and producers, right? Because if producers exercise monopoly power, the benefit from them does not fully outweigh the harm that is caused to consumers. So without picking sides, we can still say that behavior is wrong. So we cannot simply say that we need to reject total welfare because it doesn't work well with substantive equality. We need to say that since we reject formal equality, we also reject total welfare, because the two are connected. And then the question becomes, if I accept substantive equality, does this mean that I am committed to consumer sovereignty, even if I do not realize that that's the case? And this is the kind of things that we are interested. And I'm excited about the idea of consumer sovereignty and consumer welfare, because I think it allows a structured account where this division of labor between roles, sometimes I'm a consumer, sometimes I am a producer, is based on an idea of equality. It is based on this type of considerations. And the question then becomes, and this is particularly important to bring up in the digital environment, because one of the features of these more rudimentary normative concepts like formal equality and total welfare is that the main thing that they do is to limit state intervention. So if we had perfectly working markets, we wouldn't care about whether the welfare standard is total welfare or consumer welfare, because either you think it's total welfare, either I think it's consumer welfare, we will both get what we want from the market outcome in a perfectly operating market. The fact that markets are imperfect institutions implies that these kind of normative disagreements become relevant. And in the context of the digital, this kind of problems becomes even more imperative, because the complexity is higher, because very small harms to the entirety of the consumer base in a market can amount to very large amounts, right, of harm. So for these reasons, we need to have, essentially, we need to solve our problems at the normative level, at the moral level, rather fast, so that we can move forward. And the legislator needs our help, because they are very much prey of this confusopoly. So these are, for example, the priorities of the Digital Fairness Act. So competition lawyers now have their new tool, the Digital Markets Act. Now, soon they will have cases, so now they have something to play with. We consumer lawyers have been unfairly treated, because we haven't gotten anything yet, because the DSA, we do not want that. That's not our toy to play. But we have been promised the Digital Fairness Act, so we win also at the name level, I think. Now, but if you look quickly at these are, it's not me, these are the priorities of the European legislator. You can see that, first of all, subscriptions. Do we need new legislation to deal with subscriptions? What we need is enforcement. Influencers. It's one of the things that we have inherited from Western movies, that there are snake oil sellers. Not new. If we move instead to the triad, dark patterns, addictive design, personalization, these are not these are not all the same things, but these are very strongly connected to each other. And footnote, most of the problems with subscriptions are caused by one specific dark patterns, which is called Roach Motel. Now, but to insist on this point, addictive design is caused by the interaction of a series of dark patterns in the interface design combined with strong, very aggressive personalization algorithms. So the point that I'm making is that while I do understand that it makes sense to speak to the public in a way that makes it explicit that what is in the general public's understanding the big issues, it makes sense to make them explicit, I strongly fear that the academic and policymaker community does not fully realize how interconnected these things are, and therefore how important it is to have a strong theoretical framework in order to discuss them. And this is where we come in. With the visionary and insisting impetus of Behrang, we created this network. We had already 4 conferences, 2 presentials and 2 online, and we are very proud of how things are going. And we are very happy of your invitation, because we see many connections between what we want to do and what you are doing. But we are concerned, our main concerns, as Behrang was mentioning, is operationalizations. And operationalizations that are not, that of course, one of the big outcomes that we want to have with this project is one diagram. 3 years to essentially derive one diagram, but we are aware and we are concerned that it is not only a matter of diagram, but it's also a matter of what are the priors, what are the pre-comprehension, like the hermeneutical concerns, what are the worldview that people will have when they approach these kind of issues. And we see it, one example, research on addictive design strongly suggests that this is not only a children's problem. And yet the public discussion that is consolidating nowadays is primarily focusing on that. And there are reasons for that, right? You do not sound paternalistic in a problematic way if you are concerned about children. But if you start saying that adults get addicted to their phone, then you start to sound paternalistic, and this can easily erode your consensus basis. So we need to be capable of clearing out as a precondition for stronger institutions all the false linguistic problems and misunderstandings that academics have so diligently contributed to create in the last few decades. So there is a lot of work ahead, and I look forward I thank you for your attention, and I look forward for the discussion, to the discussion. Yes.